or intoxicated and you injure somebody, but that person caused the accident. This is an important issue because in Canadian criminal law, in order for you to be charged with certain offenses, it is required that your violating conduct caused the bodily harm or fatality in the case, but not always. For example, if you're charged with dangerous operation of a motor vehicle causing bodily harm or causing death, then your dangerous operation of the motor vehicle must be a at least contributing factor to the bodily harm or the death. If you're driving dangerously and then you stop at a red light like you're supposed to and somebody smashes into you while you're stopped, you cannot be necessarily convicted of dangerous operation causing bodily harm or death because the causal factor was the other person's driving. But that's not always the case. This works with impaired operation and this works with dangerous operation, but when it comes to refusal to provide a sample in circumstances where there is an accident involving bodily harm or circumstances where a person exceeds the legal limit for drugs or alcohol in their blood, the bodily harm component doesn't need that causal factor. So you could be acquitted of impaired driving causing bodily harm in that red light example where you're impaired, you're tanked, you're sitting behind the wheel of a vehicle at a red light about to go when somebody runs the light, takes a turn, loses control, and smashes into you. You're not going to be charged with impaired operation causing death or bodily harm because you didn't cause it. But if you refuse to provide a sample in the case of an accident involving a death or a bodily harm, it doesn't matter whether or not you caused it for the refusal to be considered more aggravating and to attract higher sentences, more serious charges. Similarly, if you're at or over the legal limit and there's an accident resulting in bodily harm, it doesn't matter that you being over the limit had no causal effect on the accident. So you don't just avoid legal liability just because you were not doing anything wrong in the moment that the accident happened other than being impaired or being over the limit. You still can get the same type of liability. And you should bear in mind that when it comes to impaired driving causing bodily harm and being at or over 80 in an accident resulting in bodily harm, those two offenses, you can only be convicted of one of them if you're charged with both at the same time. Oftentimes people will be charged with both. That's how it works. Typically in Canada, you get an impaired operation charge and you get an at or over 80 charge at the same time. But if you're convicted of both at trial, the judge enters what is known as a conditional stay, where one of them conditionally gets